Good afternoon everyone. In this video, Migration Consulting and Law will talk about the employment contract versus the contract for the provision of services in Colombia. This country is not flexible in labor law matters, but like everything in contractual matters, many factors can be negotiated with the employee. To understand the main difference between both contracts, in terms of the labor contract, it clearly generates additional costs. Understanding the following example of a worker earning the minimum wage. 1. Salary. Minimum salary $1.000 Colombian pesos. Transportation assistance $117.172 Colombian pesos. Total salary $1.117.172 Colombian pesos. 2. Social benefits. Premium services $93.060 Colombian pesos. Layoffs $93.060 Colombian pesos. Interest on layoffs $11.167 Colombian pesos. Vacations $41.700 Colombian pesos. Total $238.988 Colombian pesos. 3. Parafiscal contributions. Compensation benefits $40 Colombian pesos. Total parafiscal payment $40 Colombian pesos. 4. Social Security. Health contributions $85 Colombian pesos. Pension contributions $120 Colombian pesos. Occupational hazards $5.220 Colombian pesos. Full Social Security $210.220 Colombian pesos. Total monthly payroll cost $1,606,380 Colombian pesos. On the other hand, for the provision of services, contributions to Social Security must be made as an independent worker, that is, over 40% of monthly income, provided that the minimum base is not less than a minimum wage. The worker for the provision of service in this sense, he must fully pay his contribution to health and EPS, which is 12.5% of 40% of the fees, that is, 5% of the contract. In terms of the worker's pension contribution for service provision, this contributes a pension 6.4% of the total value of the contract. For the year 2022, he should pay 285,000 Colombian pesos on his fees. What does this mean? Of course, the contract for the provision of services is cheaper for the employer, and more expensive for the employee. What is the problem with its use? That in order to configure the provision of services legally and even morally, one of the three requirements of the employment relationship is broken, the main rule for configuring the employment contract, and this is subordination, so it could not be required to the worker a schedule, or to appear at the company offices in person. That is, it is cheaper for the employer, but power over the employee is lost. It is simply necessary to understand that you cannot have both, that is, to lower costs and have control over the employee, because if this were to happen, a potential labor lawsuit from the employee would be very simple, and would most likely be successful, given that the judges in labor matters, they are very protective of the workers. What to do then? If you want to reduce costs, we recommend the provision of services, giving the contractor independence, but giving him benefits such as commissions, or extra bonuses for completing certain tasks, executing very solid and clear service provision contracts. Do you want to review this information in an expanded way? We invite you to read our full article. If you want Migration Consulting and Law to help you prepare the contracts of your employees or contractors, do not hesitate to contact us.